SJC-13353, Commonwealth v. Joseph B. Sullivan and another.
Attorney Cohen, whenever you're ready.
May it please the court, Jared Cohen for the Commonwealth. With me are the trial prosecutors Stephen Carley and Dean Mazzoni as well. The Superior Court's dismissal of the indictments for misleading investigators erroneously relied on this court's decision in Barbosa, which held that a felony conviction must be set aside where there is a substantial risk that the defendant was convicted of a crime for which he was not indicted by a grand jury. There is no such risk here.
What about the use of the disjunctive or? We have two indictments. One says A or B, the other says A or B or C. The grand jury could have determined A was sufficient in both of those indictments, correct?
No, Your Honor. The reason that doesn't present such a risk is because the indictments don't charge multiple crimes. They charge the same crime committed by a single scheme on multiple dates.
No language that says it's a single scheme in the indictment, right?
That's correct, Your Honor. And the Commonwealth's pretrial motion to amend the form of the indictments was to include such language to properly reflect the evidence that was presented to the grand jury. The reason this is not an issue of ambiguity as it was in Barbosa, the indictment in Barbosa said that the crime was committed on X date, the defendant committed the crime of distribution of cocaine on X date. That indictment standing alone was not ambiguous. There's numerous indictments charged that way. What made it...
So the grand jury hears evidence that the person did mislead an investigator on this occasion or that occasion, correct?
Correct.
If the grand jury deliberates and says, yep, we agree with A, and they don't reach B, the person could be convicted of a crime that was not presented to the grand jury. The grand jury did not pass on, correct?
No, Your Honor. What this is a case more comparable to a crime of larceny by single scheme, where a single scheme, a single criminal impulse and intent unites multiple occasions. Multiple occasions can be charged.
You have to allege that in the indictment.
So I think what Barbosa shows, Your Honor, is that the court needs to read the indictment in the context of the evidence that was presented to the grand jury. What happened in Barbosa is that there was a mismatch between the evidence presented to the grand jury, where there were two drug distributions that took place on the same day, and the indictment, which simply said...
Do you agree the flaw in the indictment was not alleging a single scheme?
In this case?
Yes.
I think the fact that the indictment didn't explicitly allege a single scheme and the fact that it used the word or created the issue that's brought us before here, certainly, Your Honor, but I don't think that flaw requires dismissal under Barbosa.
Well, it may require dismissal or it may require an amendment. You asked for an amendment. The judge, in the judge's discretion, did not allow it, correct?
That's correct. And whether to...
Why didn't you re-indict?
I'm sorry?
Why didn't you re-indict? And we wouldn't be here.
Well, Your Honor, this is a situation where it's an incident that happened in 2015. Because of a continuous course of misleading conduct, indictments didn't issue until 2019. There was an extensive litigation in the trial court, including multiple motions to dismiss under McCarthy, where the trial court found...
So you thought this was faster?
Yeah, you take the grand jury minutes, you put them in a box, and you present them to a grand jury, and you draw up the right indictments. Why didn't you do that?
I think that would have been an option, Your Honor, but I think this is another option.
So this is a better option?
I think this is an important issue to clarify that the Commonwealth in this situation doesn't need to issue multiple indictments for every instance of misleading.
Or the Commonwealth should get it right when they draw up indictments.
That's certainly the case, Your Honor. The Commonwealth should get it right. I think the issue here is that if the logic of the trial court's decision is allowed to stand, in this situation, every time the prosecutors on the Commonwealth are faced with a situation, they're likely going to do one of two things. They're likely going to issue indictments for every individual act of misleading, or they're going to issue indictments which they're entitled to do under the law that don't specify any dates whatsoever.
Or say it's a continuing crime when it's a continuing crime.
I think that's another option. I think there are different things the Commonwealth could do in this situation. I think that's the crux of the issue. The Commonwealth...
Now you want a fourth option?
I'm sorry?
You want a fourth option. Is that what you're saying?
I think in this case, the evidence presented to the grand jury clearly established that it was a single scheme and a continuous course of
No
conduct.
one's saying it is. I mean, they want to, there's an attempt here to insulate these off-duty Springfield police officers. No one's saying it, I mean, that it's not, we're not saying it's not a continuing crime. You just need to say that in the indictment so that the defendant's not convicted of something he wasn't indicted for. That's all. Not that it's not a continuing crime.
Well, Your Honor, there are certainly situations where the use of the or in indictment, even if it's not the wisest choice, does not lead to dismissal. Barbosa recognized two such situations where you're talking about alternative means to the same crime or a continuing offense. Certainly, the legislature in Chapter 277, Section 31 explicitly says that you can charge in the alternative for alternative means to the same offense. It also says in Section 20 that the time of the offense need not be alleged at all if it's not an essential element of the crime.
But once you do it, you put the grand jury in a bind, right? So the other question I had is, you know, you may be right that it was a continuous crime. I think you are. That the judge probably should have allowed the motion to amend, but how is it an abuse of discretion under the LL standard for him to deny the motion to amend?
Yes, Your Honor. It was both an abuse of discretion and legal error to deny the amendment in the way that he did. If you look at the trial court's decision, he said he didn't say that he was exercising his discretion to deny the amendment. In fact, a previous amendment to amend the indictment for filing false reports, the trial court explicitly said it was allowing the amendments in an exercise of its discretion. In denying this amendment, it said it did not believe essentially that it had the authority to. It said it thought such an amendment would be impermissible and that, quote, and that dismissal was, quote, the only remedy. So that doesn't sound like an exercise of discretion. That sounds like the judge thinking that his hands were tied by Barbosa. And that was legal error and an abuse of discretion to do so.
Can I ask, and again, unlike some of my colleagues, I haven't written these indictments in my prior life, but how do we find it's an abuse of discretion if, as Justice Gassianos pointed out earlier, you could just re-indict? So it becomes a matter of pride as opposed to substance about how to redo this process. So how do we find that the judge has abused his discretion in that context?
Well, I think that the question of what happens next, how the Commonwealth responds to such an order, is separate from the question of whether he made legal error by misapplying Barbosa.
Well, but again, we're measuring whether the error has, we're measuring whether his decision to make you start over or allow you to amend, when it has no real-world significance, how that can be an abuse of discretion. That's what I'm confused by, but it may be there's a legal answer, but the fact that he didn't know he had discretion doesn't, I don't know if we can really get there based on this record.
I'm not sure that what the Commonwealth chooses to do or what its options to do in response to the order is necessarily tied to that question of whether it's an abuse of discretion. I don't think that means that it wasn't.
You say it's legal error because the judge had authority that he didn't realize he had. And there's a line of cases that say that.
Yes. Yes, that's correct. And he thought he was squarely applying Barbosa to the facts of this case when, for all the reasons noted in our brief, the case is distinguishable in a number of respects. You know, in this case, read in the context of the evidence to the grand jury, and I know Your Honor said you understand the point, but I just want to make clear for the factual context. The grand jury indicted each defendant for willfully misleading investigators on one or more specified dates in connection with the same continuing investigation into a single criminal episode. The April 2015 assault and beating of 4 unarmed black men by a group of off-duty Springfield police officers and the subsequent cover-up of that assault. The defendants were thus charged with a single crime on multiple dates as part of a single scheme.
And this is a unique case as far as lack of prejudice to the defendants because there was a McCarthy motion that said that there was sufficient evidence presented to the grand jury for all the incidents, correct?
That's correct, Your Honor, and that's the point I was getting into a moment ago, which is that there were McCarthy motions litigated for both of these defendants on all of the indictments, including the misleading indictment. The trial court found that the misleading indictment was amply supported by probable cause as to every element. And if you look at the trial court's decision there, which is at pages 43 through 62 of the Record Appendix Volume 1, you will see that the trial court, although he didn't explicitly say that, he was addressing each instance of misleading as part of a single scheme. He didn't look at whether there was probable cause as to Statement 1 and then probable cause as to Statement 2.
Had you not had a McCarthy motion, there might be a different analysis on prejudice, right?
It might be, Your Honor, but I think that the existence of the McCarthy decision makes it easier because you can look to the trial court's decision and you can look at how he interpreted the indictments, how he interpreted the grand jury evidence, and how he found probable cause on each element. However, I don't think that it's necessary for the Commonwealth's position to prevail because we do have grand jury evidence on the record in the impounded volumes 2 and 3. Your Honors are able to look to the grand jury evidence directly, which I've summarized in my brief. And I think when you look at that evidence directly, it shows exactly what the trial court found, which is that these successive multiple instances of misleading were all essentially the same statements repeated on multiple occasions to different authorities misleading about the exact same thing, which is what happened on April 15th, 2015, who was responsible for that assault, and were off-duty officers involved.
Is that the same for both defendants?
It's essentially the same, Your Honor. There are some slight factual tweaks as to the different statements.
And does that make a difference in terms of outcome?
No, it doesn't make a difference in terms of the outcome here, Your Honor.
Why not?
Because starting with Gentry-Mitchell, he made 3 statements, 2 to Springfield Police in 2015 and 1 to the grand jury in 2018. The trial court's decision on the McCarthy motion that I was just referencing explicitly found that those 3 statements were the same in substance, specifically that they consistently misled investigators by telling them that he never saw any off-duty officers at the scene, when in fact he did see at least one, and that he never heard from his partner or from the victims or any other witnesses that off-duty officers might have been involved. So
Right,
same
so
statements.
move to Sullivan.
Yes. So Sullivan, there's 4 statements. There's a statement to Springfield Police in 2015, 2 statements to the FBI in 2017, and the testimony to the grand jury in 2018. What Your Honor may be referring to is that Sullivan references in brief, he makes some inconsistent and different misleading statements, particularly in the earliest statement to Springfield Police regarding who he could identify, whether he knew that his partner and friend was involved with the incident with off-duty officers that night. He later corrects those statements. But what the trial court also found in its decision is that he consistently made the same misleading statement in addition, which was this false and fabricated account that the victims were the aggressors because they had a cab called for them and they waved off the cab, decided to stay at the scene of the fight.
So that's the same across the multiple statements for
That
Sullivan.
statement is the same across all 4 occasions. Moreover, even the other statements where there are some factual differences, the intent remained the same. The intent was to mislead investigators by providing a false and misleading account of what happened on the night of the assault, who was involved, and specifically whether or not off-duty officers were involved in the group.
It doesn't matter that they're different police agencies, correct?
It doesn't, Your Honor. I think what matters is the intent. Under 13B, we have a dual intent requirement, intent to mislead an investigator, one of the investigators listed in the statute, but also an intent to impede the criminal investigation. And I think that's the critical aspect of the intent here. The intent was the same, to mislead the same criminal investigation into the same incident.
With different law enforcement agencies,
That's correct. And I think it's important.
different dates.
That's correct. Because it's the same issue that all of the agencies were looking into the entire time, which is what happened on that night and who was responsible. The fact that it wasn't resolved by a Springfield police investigation in 2015, the fact that it required FBI investigation and ultimately a statewide grand jury, doesn't change the fact that it was the same issues. We were still trying to get to the bottom of what happened and who was responsible. A little additional factual context I want to get into is that, again, indictments didn't issue in this case until 2019. At that time, a grand jury indicted 16 individuals in total, including 11 individuals who were charged with various crimes related to the cover-up, filing false reports, misleading investigators under 13B, and perjury. Almost all of those individuals made those statements on multiple occasions. Most of them were in the same situation as Sullivan and Gentry-Mitchell, where they repeated the same misleading statements to investigators again and again and again. At that point, the Commonwealth could have charged those misleading statements in multiple indictments. It chose at this stage to charge a single indictment for misleading investigators while listing the dates in the indictment to give fair notice to the defendants. If the Commonwealth had opted to charge by multiple indictments, that easily would have ballooned the total number of indictments in this case from the dozens easily into the hundreds. Alternatively, if the Commonwealth had charged without specifying the dates, it would have presented no problem under the law, but it would have provided much less fair notice to the defendants. So in this situation, indicting with one indictment per crime, per individual, but specifying the dates therein, the Commonwealth chose a course of action that provided the simplest, the clearest, most reasonable fair notice to defendants. I see my time is up, so if Your Honors have no more questions, I will ask the court to reverse the judgment of the trial court.
Okay, thank you. Attorney Kelly.
Thank you. May it please the court, Daniel Kelly on behalf of Justice Sullivan. I'm asking you to uphold Judge Mason's order. While there's a multifactorial test, it really is fact-specific. In this particular case, the facts fall squarely within Barbosa. Barbosa was a gentleman who stood on the same street corner in Boston over the course of 15 or 20...
But isn't this not really like Barbosa? Because we had a trial in Barbosa, right? I mean, Barbosa, you had a trial, and you knew that the jury was given two instances on the same date, and there really wasn't any way to divine which particular instance they were talking about. Here, we haven't had a trial. You know that at trial you can ask for all types of things, right? You can ask for special verdict forms. It doesn't have to be a general verdict, because if you had a general verdict form and then a conviction, now you've got a Barbosa problem, right? Because we can't figure out which one of these dates. But you can use a special verdict form. You ask for unanimity instruction. There's all types of things that makes this different than Barbosa.
Well, I don't think a specific unanimity form, I knew I'd have trouble with that word, would remedy the Barbosa issue. A specific unanimity form would determine...
As to each date.
But that wouldn't remedy this particular issue as to what exactly the grand jury indicted him on. It would remedy what the jury convicted him on, but it wouldn't remedy what the grand jury indicted him on, which is what Barbosa says.
Okay, so is this back to Justice Gaziano's point that if the indictment had read a continuing scheme, you wouldn't be here? You wouldn't make that argument?
Well, it would certainly make it a less persuasive argument, but the bottom line is here that disjunctive or is important. Just not putting that aside is a significant issue. In the or cases that they cite, the judge allowed particular motions to amend.
Every child rape case has that.
Yes.
Did on diverse dates do this? That's, I mean, you litigate cases that's every child rape case.
Absolutely, but those are...
You want us to validate every child rape indictment too?
No, but those are particularly, I mean, that's the same exact victim doing the same exact acts to the same exact victim. Here, that's not what we have. Sullivan makes a statement in 2015 to Springfield PD investigating one aspect. He makes two statements in 17 to the FBI. He makes two statements on the same day in front of the grand jury and before the grand jury. How do we know on that day who the grand jury indicted him on? Did they indict him on what he said before, to the FBI and to the state police outside the grand jury room? Or did they indict him for what he said to the grand jury? How is that not exactly like Barbosa? In Barbosa, he had someone who sold drugs to person A, waited 15 minutes later, took it out of the same stash, his own mouth, and handed it to person B. And we didn't know who the grand jury indicted him on. How do we know the words that came out of Mr. Sullivan's mouth in position A, speaking to the people, the investigators before the grand jury, or was he indicted on position B, the words that came out of his mouth in front of the grand jury? That's exactly...
Which would have been cured by a continuous scheme language.
It would have been, but we don't know that the jury...
So now we get to whether or not it was error to deny the amendment.
So it was an error. I mean, this is a very fact-specific case. Judge Mason get into this idea of, well, did he know he had the discretion or not? He made factual findings, and I know you take it de novo, but he didn't. It wasn't as though he was unclear as to what his role was. He made factual findings that the amendment in this case stretches impermissibly thin Barbosa. And really, if you think about it, almost all of the attacks on Judge Mason's ruling in this case could have also been made before you at the hearing of Barbosa. This is really cloaked a attack on Barbosa.
Barbosa's not a continuing crime case. It's two different two different drug deals. This is one cover-up.
And in Barbosa, they mentioned that, right? That this isn't a continuous thing because they would said if it were, it would be very different.
Right. But in this case, how is that any different if you think about it in this case? It's easy just to step back and just say, well, this is one cover-up. But really, he's speaking to multiple sovereigns, multiple agencies. I mean, the FBI is investigating not for criminal acts that are germane here, the state statute. They're investigating civil rights. They're investigating a whole nother set of statutes. It's a whole different sovereign over the course of years.
His intent is to cover up for his buddy.
Well, I don't think that's necessarily the case that the grand jury had. He makes inconsistent statements across the course of this investigation.
Do you admit that you wouldn't be prejudiced because it was a McCarthy motion?
The McCarthy motion denial is interesting, but it still doesn't get into what the grand jury did. It's based.
I'm asking about the decision not to allow the amendment, whether that's an abuse of discretion.
No, it's not. It's not abuse of discretion. The judge made a factual finding that it's in this particular case, Barbosa applies, and that these were separate acts, and that putting them together.
So if we look at the Barbosa language and it says, because I read it and you did too, this does not apply to continuous crimes, and we think this is a continuous crime, and the judge was wrong, is it an abuse of discretion not to allow the amendment?
I would have to agree with that. If you find that, yes, because that's not the. But I would urge you strongly to look at the facts of this case. The date, and again, I made an error and omitted something for the record. I asked leave to submit. The grand jury, you might have heard in their reply brief, did not. They suggested in the reply brief that the grand jury didn't hear about the two instances on that one day in the 18th. The grand jury did. I can provide that in a letter, and I'll simply provide that if the court allows that, me to submit pursuant to your rules afterwards. But they heard that. So how is that any different than Barbosa? It's not a continuing act. It's two different acts on the same day, but it's not a continuing act because it's all across the board over the course of 3 years. It's internally inconsistent. How could it be held to cover up for certain people that in certain dates he doesn't cover up for them? Thank you.
Okay, thank you. And Attorney Fogarty.
May it please the court. Edward Fogarty for Defendant Mitchell before the court. Mr. Mitchell, as you know, is charged with 3 counts, if you will, within the indictment of misrepresentation. 2 occurring to the Springfield Police Department and 1 to the grand jury. I would argue that the trial court found that there were 2 targets, namely the police department and the grand jury. I would argue that there is room for argument here that the 2 targets within the police department are in fact 2 different targets. One was the major crimes unit where they are investigating criminal activity. The internal affairs unit, or whatever the title was, is looking for basically administrative disciplinary actions against the police department. So there is a distinction to be made, and I would argue that there in fact you could hold that there are 3 targets in this particular case. In any event, the Commonwealth argues that they would be allowed to amend the indictment to make it a continuous scheme or continuous crime. I would argue again that that's not necessarily the case, and the case cited by the Commonwealth in support of their position is one involving larceny. And the cases that support these kinds of continuous crimes are pretty much larceny or embezzlement or types of schemes that can go on over many years with spots, individual transactions leading up to the ultimate larceny against a single victim. Here we have at least 2 victims, 2 targets, unlike the cases cited by the Commonwealth where there is one single target. So I would argue that the Commonwealth is trying to backdoor in the continuous intent amendment as a way of overcoming what was their poor drafting in the indictment itself, namely the use of the word the disjunctive or. Had they simply had the word and, we probably wouldn't be here. Had they just gone back and re-indicted, as was brought up by Justice Gaziano, we wouldn't be here. Instead of that, we're before this court on an issue involving multiple targets multiple victims, which is not supported by the record, and I would ask you to support the trial court's decision.
Were you prejudiced by this if he allowed it?
Well, I think it would be. You wouldn't know, what did the grand jury decide? Did they decide that Mr. Mitchell was responsible for misrepresentation to law enforcement, to the grand jurors? And I might add that the grand jury was at the same time considering a perjury charge against both of these individuals. It could equally be that the grand jury decided, well, we're going to issue a perjury charge here. We really don't need to have a misrepresentation charge. We simply don't know.
They returned perjury.
They did.
Right.
So it could be that we just don't know. We don't know what the grand jury was doing because of poor drafting on the part of the Commonwealth, and that should not prejudice the defendant in this case. There are no other questions? Thank you.
Okay, thank you.